All right. Well, good afternoon, everybody. It looks like it is about 12 o'clock here. This is the webinar for what happens to your money when you die. So we're really excited to talk about this topic. We do have just a couple of housekeeping things to go over before we get started, just how to interact with us, how to ask questions, and we'll be able to share all that with you. So if you're on a touchscreen device, an iPad or a phone, something like that, go ahead and tap the device, and then at the bottom right there, you'll see a few prompts, and that's where you'll be able to view the handout today and also ask any question. If you are on a desktop or a laptop or something like that, it's a little bit different. You'll see a toolbar there that you can expand or minimize. And there's a section there a little bit below where it says handouts. You can expand that and see the presentation. And then below that is where you can ask questions. Now we've got a lot of really good questions that came in prior to the webinar starting. We asked all of our staff, what are your clients asking you every time that you meet with them? And this is a really popular topic. So we have a ton of questions. We'll do our best to get through all of them, but if we don't get through it, if you're a client of Fort Pitt, then your advisor team would reach out to you and speak with you individually. And if you're not a client yet, then myself or one of our other advisors will reach out and see if we can help you out. So my name's Skylar Riddle, and I'm an advisor here with Fort Pitt, certified financial planner. And it's very happy to be here. My wife and I live north of the city with our 2-year-old daughter Caroline, and she's a firecracker. She keeps us young, but really tires us out. So this is a topic that's important to me as well, because it's all about her. I want to make sure that she's taken care of. And Mike's here with us here, and I'll let him introduce himself.
Thanks, Skylar. And also, I just found out that Skylar has a baby on the way. So that's his wife has a baby on the way. So that's fantastic. Yes, we've always wanted to do this webinar. It's a popular topic. I'm Mike Blehar. I'm one of the founding partners of Fort Pitt Capital Group. We have been in business here since 1995. I have 3 kids of my own who are grown. They have signed up for the webinar. So I don't know what to make of that, because I did tell them what's going to happen to my money when they die, but they're still, maybe I should be nervous that they're watching.
Yeah, they were pretty eager, I think.
Yeah, I know, they were. So my role as one of the managing directors of the firm is to guide the strategic vision of what we do here at Fort Pitt Capital Group, and that is to make sure we're delivering exceptional financial advice, and that we're making sure that we're taking good care of our clients' portfolios. Okay.
So this is something that we do often. So we encourage, we want to invite all of our clients to our many webinars. We'll tell you a little bit about some that are coming up here after hours. And we hope that you find this topic interesting, and maybe some others as well. But we like to reach out to our existing clients and people in the community to make sure we're taking good care of not just their financial assets, but really their life. Yeah. And I think you have a pretty good saying that you want, before they do anything, to reach out to us, right?
Right. One of our favorite sayings is before you make a financial decision, if you're one of our clients, before you make a financial decision, talk to us first. Don't do anything without talking to us first. It doesn't matter whether it's buying a house, buying a car, doing your retirement planning, doing a rollover, setting up education funds for your kids, your grandkids, refinancing a mortgage. I mean, it really, we're here for our clients as their coach, as their trusted advisor. That's the principles that we founded the firm on. We founded Fort Pitt Capital Group in 1995. All of us that came from another firm started this firm to do 2 things really well, and that is to provide good, sound financial advice where we're helping our clients organize their financial life and managing their money for them. We manage approximately $4.5 billion for clients of all shapes and sizes. So individuals, corporations, 401ks, nonprofits. So although we are somewhat large in comparison to other RIA firms, we're still small when compared to very large firms. So we can provide very good personal service to our clients. So this is the biggest webinar we've ever had. We have 250 participants signed up. We got a ton of questions prior to the webinar that we're going to try to get through. And then as we're talking, as anyone sends a question in, Skylar's got his cell phone. I don't want you to think he's looking at sports scores or something like that. Miranda, who's in the back running this webinar, is going to text any questions that we get. So we're going to try to get through this. The reason we're doing this is, Skylar's been a financial advisor for 10 years. I've been a financial advisor for 30 years. This is not going to be a deep technical estate planning webinar. This is the questions that are the basics that people say to us all the time. Well, when I die, how does my money get to my kids? How does it transfer to them? What are the taxes going to be? I don't know an attorney. How do I get an attorney that knows what they're doing to help me with this? What if my kids aren't good with their money? It's just these questions that to us are pretty simple, but to our clients are very, very concerning. So we just want to try to, on the one hand, we want to try to put everybody somewhat at ease today about the process. But on the other hand, we do want to make sure you're disturbed enough that you get with an attorney and you get some advice, and maybe we can help you get things in order. Okay?
Absolutely. Yeah, that sounds good. So
and also too, we wanted to try to organize these in some logical fashion. So we did our best.
Okay, you're right. Well, why don't we just start with the question that is on the webinar? What happens to your money when you die, specifically when you don't have a will?
Yeah, if you don't have a will, I'm going to say this: shame on you for not having a will. I'm just having to start this thing off by scolding people for not having a will, especially if you have children who are minor children. So look, if you don't have a will and you die, who's going to know what to do to handle your affairs? Okay? Is it your brother? Is it your sister? Is it your kids? Is it your mom and dad? I mean, who's going to step in and organize your estate, make sure that the estate is administered properly, and make sure everybody gets the money who's supposed to get it? So if you don't have a will, that's called dying intestate, and someone has to go to the court and get appointed as the administrator, and then they have to figure all your stuff out. Okay? They don't have the passcodes for your bank accounts. They don't have the passcodes for your brokerage accounts. So unless you have all this in order and you don't have your will and you don't have instructions, you are leaving a big mess for your family. Okay?
You probably have, some family arguments, your brothers and sisters and aunts and uncles, and everybody's fighting over who's in charge, or you owe me this money, right? I mean,
exactly. And what about if you have kids?
Right.
Okay, so if you have young children, minor children, who's supposed to be the guardian who takes care of the kids day to day? And then who's supposed to be the trustee of the money? Because the money that you leave your kids, and if they're minor kids, it doesn't go right to the kids. It has to go into a trust for the kids. So who's going to manage the trust? Who's going to be the trustee? And who's going to be the guardian? Because the guardian and the trustee should not be the same person. Okay? I know you might trust your sister and your brother-in-law, or your brother and your sister-in-law, or whoever it may be, or your mom and dad. But if the guardian is also in charge of the money, the guardian might say, you know what? It's really hot. These kids need a pool.
That's right.
And these kids really deserve a vacation. So let's pull some money out, take them to Europe, because, okay, you see our point. So get a will. Get a will.
Got it. Okay.
Get a will, get things in order.
That's step number one. No, that makes sense. Everybody should have it. So let's talk a little bit about debts, because a lot of people have debts now and when they pass. So what happens to that?
Well, that's another big question. Okay, so now I'm gone, and there's a mortgage, there's credit card debt, there's a car loan. Do these debts evaporate, or do they have to be taken care of? And the answer is the debts need to be relieved by your estate, okay? So whoever is your executor, okay, now let's say you do have a will and you do have an estate plan. Whoever your executor is going to make sure your debts are paid. So you don't get out of debt by dying. Skylar, is there any debt that is forgiven?
If you're federal student loans, if you have that and you pass, then they don't come after anybody for that. So that's really it. You're at liberty of the creditors coming after the estate, and it can be a process for them to go after it. So
okay,
that's all that you can discharge.
Okay. All right, so that's it, just student loan debt. All right, well, hopefully, people don't have the student, well, most people die after they paid off their debt, but something happens, you never know.
Right, you never know.
Yeah.
And then, sometimes it makes sense to, have life insurance to cover debts or those sorts of things as well. It doesn't all have to come from the estate account. Is that right?
That's true. It doesn't have to come from the estate account. It could come from life insurance. And life insurance is a question that we've had, but that is an entirely different webinar where we talk about the benefits and the usefulness of life insurance for estate planning and family planning. That's something we'll do at another time. We got a lot to cover here today.
Absolutely.
Yeah.
So let's talk a little bit about beneficiary designation. So there's some fancy terms. Maybe they've heard of a POD or a TOD account. You say you need to have that. And shed some light on what those accounts are.
Yeah, that's a common question too, is should I have my account set up as a transfer on death, a payable on death, a designated beneficiary account? They're kind of all the same thing. So one thing that's really important, if you're participating in a 401k plan, if you have an IRA account, you need to make sure that you have a designated beneficiary on those accounts. If you do not designate beneficiaries on your IRA 401k, there could be adverse tax consequences. So that's one of those housekeeping things that you need to make sure you have done. And on an IRA, typically, if you're married, your spouse is your beneficiary, but then you should also be naming contingent beneficiaries, which are typically, if you have kids, are your kids. So primary and contingent beneficiaries on an IRA are important, all right? What about non-IRA accounts? Non-IRA accounts, we can go either way on this. On a bank account or on a brokerage account, you can name a beneficiary. You can name a beneficiary, and when you think about this, when you die, the money would go directly to those beneficiaries without going through probate. So that sounds like a good idea, right? Because I avoid probate. And then IRAs have a designated beneficiary, so they also avoid probate. So people go, ooh, that's really good. I can avoid probate.
That's right.
Okay, but that beneficiary designation supersedes your will. So let's say your will says, I want to leave money to my 3 kids, and I want to leave money to this charity and that charity, and then I want to leave some money to my nieces and nephews. Well, if you designate the beneficiary on your brokerage account as your 3 kids, they get the money, the charities don't get anything, and the nieces and nephews don't get anything. Okay, so you've got to be careful that the beneficiary designations match up with your will. Lastly, and this is something that we've encountered numerous times. I guess I use the 3-kid example because I have 3 kids. But we've had cases where there's been a beneficiary designation, the money goes to the 3 kids, and not all of the expenses are paid. The estate expenses are paid. Taxes aren't paid. Attorney isn't paid. Funeral home isn't paid. So now everybody has the money individually. And we had a number of times where one of the kids is not financially sound. And now these two kids who are financially sound, and when I say kids, I'm talking about people in their 50s, 60s, because people generally aren't inheriting money until they're that age. But now we've had conflicts where these two kids are trying to extract from this kid the final expenses of the estate,
Right.
and this kid doesn't want to give up the money. So we're not big fans of doing the beneficiary designation on non-IRA accounts. We'd rather have the money go into what's called an estate account. Very common. When we have clients die, we set up the estate account for the client, and we work with the executor, and the non-IRA money goes into the estate account. We make it happen. We get it in there, and we're not having to sell anything, or we just move let's say it's stocks or mutual funds, we just move it into the estate account. And then the executor has a checkbook, and they have access to that, and they write checks to the attorney and the funeral home and to the tax man. And then after all those expenses are settled, then the money can be distributed out to the remaining heirs.
Absolutely. That's the way to do it. And I mean, there's a lot of confusion sometimes about probate. What is that? What about my wills? What about beneficiaries? So even if you have beneficiaries on your account, you still need a will, because those beneficiary designation only account for that money. Doesn't account for your home or your personal possessions. Who gets your grandmother's diamond ring or that sort of thing. So you still need a will no matter what, if you have beneficiaries or not. But I'll talk a little bit about probate, because sometimes people get a little nervous and I don't want anything in probate. And it's not that bad. So your will does go through probate. A lot of people think a will goes outside of probate, but by definition, it goes through there. But it's a pretty simple process. And like Mike said, we're here to walk you through it. So you get up one day and you bring the death certificate down to the courthouse. Maybe you go out for a nice breakfast and coffee with family in the big city.
Or your attorney goes.
Or your attorney. Yeah. But you go to the courthouse and you get appointed by the court as the administrator of the estate. And you use that document to open up the various estate accounts with all the bank accounts that they had, investment accounts. So it's not a big scary process. It is a public process. So if there is anything that you wanted shielded from the public's eyes or unsecured creditors, beneficiary designation is a good way to do that. But it's nothing to really lose sleep at night. It's okay to have some things go through probate.
It is. I remember a situation where I had a client call me out of the blue, and she was trying to do the right thing for her family, and maybe forgot that I said, oh, you should always check with us first. Don't do anything before you talk to us. And she called me and said, oh, I got a trust. I got a living trust. And I said, okay, well, why did you do that? She said, well, if I do this, it's going to avoid probate for my family, and it's going to save me taxes. And I said, well, no, it is going to avoid probate, but it's not going to save you taxes. A revocable living trust is not a tax avoidance vehicle. And I said, how much did you pay the attorney for that? And I didn't know the attorney, and I usually do know the attorneys for my clients. And she said I paid $3,600 for this trust that she did not need. And I didn't want to make her feel bad. And I said, okay, fine. But I thought, oh boy, I hope the attorney did not try to persuade her that this was going to save taxes. And maybe the attorney just knew she thought that it would avoid taxes, but didn't clarify that. So it was $3,600 that was an unnecessary expense. So you got to be careful about what people are advising you, especially when it comes to trusts, what they're for, and their effectiveness.
Yeah.
Okay.
And you bring up a good point with that, where we work with some of the greatest attorneys and CPAs, lenders across the nation.
Yeah.
So if you don't know somebody, or you're not feeling 100% confident in the person you're working with, let us know, and we can point you in the right direction. I mean, that also brought up a question that came through, was about how are attorneys compensated? Because there's a lot of gray area there.
Yeah, a lot of times people are hesitant to reach out to an attorney because they think it's going to be too expensive, they don't know how it works. And in our case, we are our advocate for our clients. So if our clients don't have an attorney, we get them to one who fits their circumstance. If they have an existing attorney and we're unsure about whether that's the right attorney given their circumstances, we might suggest a different attorney. But how do attorneys get paid? It's a common question. We get this question all the time. So number one, when we refer a client to an attorney, we'll say, please ask that attorney how they're going to be charging you to do your estate plan, to do your will, and how are they going to get compensated when you die? Because sometimes it's different. Well, sometimes it is different. So usually it's a flat fee to do your estate plan or an hourly fee to do your estate planning documents. Then when you die, here's where we've run into trouble. The attorneys we work with, by and large, the attorneys we work with are charging an hourly rate to settle an estate. But attorneys are permitted to charge a percentage of the estate, which many times is far more expensive than the hourly rate. Give you an example. Had a client, husband passed away. They had an attorney here in Pittsburgh. The couple lived up in Katanning. And the woman said to me, I said, okay, are we going to use this attorney here to settle your estate? And she said, no, I have a friend up here who's an attorney, and she's going to take care of things because she said, hey, these Pittsburgh attorneys, they're real expensive. I said, okay, fine. And she's your friend. So as things progressed, I said to my client, you know what, how much is your friend going to charge? Because I called that attorney and I had some questions, and she gave me answers that were actually wrong answers. And then she started asking me questions, and that was a big red flag. So I said to my client, call her and ask her how much she's going to charge you. She called the attorney's office, and the attorney's paralegal said, well, since you're a friend, she's going to give you a discount, and she's not going to charge you 10% of the estate. So she's only going to charge you $15,000 to settle the estate. So my client called me. She was very upset. She said, $15,000, that sounds like a lot of money. My first reaction was, do you want to call and fire the attorney, or do you want me to call and fire the attorney? I said, we are not going to do this. I called 5 other attorneys who I know very well. I said, okay, here's the circumstances of the estate. There's a house, there's an IRA, there's a joint account. What would you charge to sell the estate? One attorney said, probably $2,500. Another attorney said $5,000. Another attorney said $1,000. Another one said, I don't know, I'd have to, look into it, but not more than $5,000. So instead of $15,000, because we intervened, we got that estate settled for $2,500.
Unbelievable. That's a lot more money for her, for her family.
Yeah.
Go out and do whatever she wants.
Oh my gosh. Totally blew me away that someone was willing to charge a friend $15,000. I'm going to give you one more real quick. Had a discussion with an attorney who would like to do business with us. I said, how much do you charge to do an estate plan? They said, oh, anywhere from $1,000 to $5,000, depending on the circumstances. Could be more, again, depending on how complicated things are.
Right.
I said, well, how do you charge to settle the estate? Oh, we charge 1%, and we charge X% on probate assets and X% on non-probate assets. And I said, let me get back to you. So I got back to them and I said, let me give you an example. Here's my clients. They have this. They have a house. They've got these assets. And I said, by my calculations, what you described as the percentage that you charge, you would be charging my client $110,000 to settle their estate. And the person said, well, let me get back to you. I don't think it's going to be that much. Got back to me. They said, no, it's going to be less than that. It's probably going to be more like 75,000. So that was it. Because that, again, I went to some other attorneys that said, let me give you these circumstances. What would you charge?
Right.
And it was a range in that case from like $3,000 to $10,000, not $75,000. So we step in, someone dies, and they're working with an attorney. If we're not familiar with, we say, okay, let me meet that person, or please ask them what they're going to charge. And if we hear a story like that, we're like, okay, let's put the brakes on, let's go somewhere else.
And Mike, a common misconception is that just because an attorney drafted your will doesn't mean that they have to settle the estate.
That's right. The attorney who drafted your will does not have to be the same attorney who settled the estate. We just want to make sure that our clients are with the right attorney and they're being charged a fair fee to settle the estate.
Absolutely. So we get also a lot of misconception and with all the terms, and it can be confusing with beneficiaries and executors and powers of attorney. So one thing that comes up a lot is, well, I have a durable power of attorney already. So do I need to have an executor, or do I need to have them listed as beneficiary? And really, it's important to have that durable power of attorney. It's important to have a living will and an advance directive, because those are all things that you need while you're alive. So a durable power of attorney is someone who can act on your behalf while you're still here. But when you pass, that durable power of attorney goes away, right?
Yeah, it does. Just because someone has a power of attorney when you're living doesn't mean that they still have that power when you die.
Right. So
then that's when the executor is going to be stepping in, or the executrix is going to be stepping in. So yeah, it's important to have a durable power, and a durable power means, well, if I'm incapacitated, generally husband and wife have durable power, or if you're unmarried, it's a brother or sister, someone who's you trust. They're there to act on your behalf if you become incapacitated. Healthcare power of attorney, financial power of attorney, and then also when you get your documents in order, you'll have those. You'll also have an advance directive that says, oh my gosh, if I'm in a vegetative state and I'm not going to make it, here's what I want you to do. How long do you want me to be plugged in or not? Sorry to be so blunt, but you need that too. One other thing that I want to mention that I don't think a lot of people think of, and you think about me, my kids are 30, 27, and 25. And I know I don't look old enough to have kids that old, but anyway, my kids are all of the age of majority, but they still do depend on mom and dad for stuff. And if, unfortunately, not financially, my kids are off the payroll, so that's a good thing. But if they get sick, or they're in a car accident or something like that, you got to keep this in mind. Beth and I, we can't call the hospital in Philadelphia where my daughter lives, or LA where my other two kids live, and say, hey, my son's in the hospital, tell me what's going on. They're going to say, no, we can't talk to you. So if you have non-minor children, especially kids who are in their 20s, maybe early 30s, who still need your help, God forbid if there was some sort of healthcare incident, you should have a healthcare power of attorney for your kids who are non-minors. So I had my kids all sign. It's real easy. The attorney just drafted them up. We were on vacation. I took this stuff on vacation. I said, here, you need to sign this, because if something happens to you, Beth and I need to be able to call the hospital and say, tell me what's going on. And they're going to say, send me your healthcare power. We could just email it to them and say, here, talk to me.
Right.
It's very important.
Yeah, it's not a time where you want to be stressed out. You want to just be able to get to them as quickly as you can.
Yeah.
So you mentioned executor, executrix, and basically that's just someone that who you trust that would help settle your estate. Now, I mean, is that able to be an attorney? Are you allowed to outsource that? Does that make sense sometimes if you don't have that trustworthy person in your family?
Yeah, so with the executor or the executrix, usually husband and wife are executor for each other. And then if you have kids, then it's kids, okay? If you don't have a spouse or you don't have kids, it can be the attorney who drafted your document. It could be a brother, sister, aunt, uncle. It could just, it needs to be a person that you trust to settle your affairs, So in my case, if I'm gone, Beth is the executor. If we're both gone, my kids are co-executors, or I could have just made one of them executor, but they're co-executors because I trust that the three of them can work together to settle our affairs. But you know what? I'll take it a step further because the five of us travel together on vacation. So what if we're all, snorkeling in the Bahamas and a gigantic shark comes and just eats all of us and we're all dead?
Seen those movies, yeah.
Yeah, I mean, shark could eat us all.
Right.
Big shark. So if that's the case, my nephew, who is an attorney, is the executor. So he steps in and Ben knows where all of our stuff is and Ben comes in and he settles this. So, you've got to think a few levels out when you're doing this sort of planning.
Yep,
Yeah.
absolutely.
Yeah.
Now, I think probably the most common question we had was around taxes. What can we do to avoid taxes? How are things taxed? So, if it's all right, I'll talk a little bit about that initially.
Yeah, you just went through that with somebody, so you should talk taxes.
Right.
Yeah.
So, you really, as long as your estate is underneath the federal exemption, which is about $11.5 million now. Then per person, right? If you're married, then that's double. Then you're not going to have any federal estate tax. So a lot of people, you don't have to worry about that. But if you live in the state of Pennsylvania, for instance, which a lot of our clients do and a lot of people on the phone here do today, there is a PA inheritance tax, and that's 4.5%. Now, there are some other states out there, I think there are 17 maybe, that have inheritance tax. So if you live in one of those other states, still talk with us and we can get you that number. But most of the time, you're paying 4.5% on that. And that's to normal heirs in your lineage. If you pass it to your children, then that's where that 4.5 comes into play. But where it gets a little bit more is if you're passing it, maybe you don't have children. And there's a lot of people that don't have that. Maybe you want to pass it to your brother or sister. Well, if you're passing it to them, then that's 12.5% tax in Pennsylvania.
Right.
And if you're passing it to your niece or your nephew, then that's 15% tax. So it really does add up depending on who you're going to gift that money to. And we're fortunate to have a lot of charitably inclined individuals in Pittsburgh and as clients all over. So that's a great way to give some money. They don't have to worry about any taxes. But it's just something to keep in mind. If you are, if you're really close with Aunt Betty and she doesn't have any children of her own, and she lives by herself and you take great care of her and she says, look, I'm going to be giving this to you when you pass away. Well, you have to come up with a way of doing it where you don't, sound like a money grubbing fool, but you can say, hey, Aunt Betty, there's some great ways to maybe gift that while you're still here. And we'll talk about gifting a little bit later as well. But just broadly speaking, if it's a regular account, non-retirement account where that money is being transferred, then you're going to be getting hit with those taxes, and it can really add up over time.
Yeah.
So yeah, go ahead, Mike.
I think right along with that, the other questions that we've had is, well, how can I avoid the 4.5% or the 12.5% or the 15%? And a common question that we've gotten, every year, I think I'm answering this question a couple times a year. Well, what if I sell my house to my son or my daughter for $1? And that way, then they own the house, and we can avoid inheritance tax. It's a common question. We're not a fan of that idea. A couple things. Think about this. I'm trying to avoid 4.5% tax. All right. So I'm going to sell my house to my daughter for $1. Now my daughter owns the house.
Pretty good.
Okay. So let's say it's a $350,000 house. But uh-oh, wait a minute, my daughter was in a car accident and now she's getting sued, and they're going to try to take assets from my daughter, which include my house. So that would be bad to have someone now take the house or the value of the house in a lawsuit. Bad idea, okay? And I sold my house to my daughter for $1, and now she and her husband are gonna get a divorce. And now half of the house value gets taken away in the divorce. Here we are, we're trying to avoid 4.5% tax, which is a little over $15,000. What if none of these adverse things happen? There's no divorce, there's no lawsuit, but now I die. My daughter now has my house, my $350,000 house. So guess what? We avoided 4.5%.
Pretty good.
Pretty good, right? Yeah. But wait a minute, what's the cost basis in the house?
She bought it for $1.
She bought it for $1. So she has a $350,000 house that she bought for $1. And now she says, I'm gonna sell the house for $350,000. And Skylar, what just happened when you sold for $350,000?
Well, now you have a capital gain event. You have to pay taxes.
So now you have to pay capital gains taxes on the sale.
Mm-hmm.
And Skylar, on a $350,000 sale of a house, what would the tax be generally?
I think minimum would be 15%, but probably about 20%.
So now I have a tax due. I avoided inheritance taxes of 4.5%, which was a little over $15,000. And now I sold the house and I have to pay $70,000 in capital gains tax. So now you see why we're not fans of selling the house for $1.
Right. Yep. There are better alternatives for sure.
Right. There's if people want to have a tax avoidance strategy, that's a whole different seminar.
Mm-hmm.
But there are tax avoidance strategies that we work with our clients and our clients' attorneys. So, but things like that, they sound simple, they sound easy, but they can be very complicated, and they could end up having a worse tax consequence than the 4.5%.
Absolutely.
Yeah.
Now we kind of open up another can of worms with step up in basis and other things. So kind of to continue on the tax road, we'll talk a little bit about retirement accounts. So and there are some recent changes with the Secure Act not that long ago.
Yeah, that's why don't you talk about what happens with IRAs, what used to happen with IRAs and what happens with IRAs now?
So, in the past, before the Secure Act was passed, then what happened if you had a 401k or 403b, an employer retirement plan or an individual retirement account? That money would transfer to your beneficiaries, and it would be based on a little bit on your age. Were you already taking out minimum distributions, or were you younger than that? But what we would do here is we would put that money in an inherited IRA. And then we would look at all of those factors and determine how quickly you have to take that money out. Because especially if it's not a Roth account, right, you have to take money out and you have to pay taxes on that. And that's regular ordinary income tax. So that's different than the Pennsylvania inheritance tax that we talked about. So the time frame was different for everybody. But now with the passing of the Secure Act, anyone who passes away now, it depends on who you are.
Yeah.
So if you pass it to a husband or a wife, then you can treat it as your own. You have a few options.
Yep.
If you pass it to someone who is within 8 years of yourself, then you're an eligible designated beneficiary. So there's a few other benefits with that you can treat it as your own, less restrictions to take it out. But for most people, the rule is now you have to take it out over a 10-year time frame.
Right.
And it's simplified the process a little bit, because now we don't have to, see what the required minimum distributions are, but it requires a lot of planning, because now the clock starts. We have 10 years to get that money out. Penalty is severe. So what happens if there's still money when the clock strikes zero? It's a big tax penalty.
Yeah, this change really is causing us to need to work closely with beneficiaries and try to figure out the best approach for distributing an IRA in this compressed time period, because it's 10 years. You could wait until the last day of year number 10, but if that IRA grows to be worth $3 million, you're gonna pay tax on a $3 million distribution, okay? So this now has caused us to do more tax planning. The other thing that it's causing clients to want to do is to say, geez, if my kids or my heirs are gonna have this inherited IRA, which they have to accelerate distributions over a 10-year period, is there anything I can do to help them minimize the tax? And yes, there are things that can do. There's potentially insurance could come into play, or converting some of the money now to a Roth IRA, where you as the owner of the IRA are taking the tax hit now because you think taxes might be more for your kids down the road. That's another avenue that you can take. So we've got a lot of generous clients who are saying, yeah, I'll take the tax hit now, try to save my kids' taxes later. But there are some options that you can do to try to counterbalance the tax burden that's going to occur in that compressed 10-year time frame.
Absolutely.
Yeah.
So I mean, it's good. That's why we need to have these conversations.
Right.
We kind of along the similar path, probably the second most, maybe tied, if you're putting it in the same category, people were asking about trusts, and they think that just putting it in any old trust would save taxes. I know you touched on that a little bit earlier, but talk about that strategy. And again, I know we're not attorneys, we don't draft the trusts,
right,
but we have these conversations every day.
Yeah, again, a lot of the motivation is, are there certain trusts that I can utilize to help save taxes? Again, it's another webinar, okay, where we probably want to bring in one of our attorneys who could talk chapter and verse on all the different trust mechanisms that people could use to do tax avoidance. A lot of times that would imply an irrevocable trust, which now you've given up, potentially you've given up a lot of control of those assets, and most people don't like giving up control. So that's just something where if we have a specific circumstance where someone is so motivated to avoid taxes that we would be sitting down with that person, with their attorney, saying, okay, let's think this through. What might work best for this? And it's just too much to try to go over in a discussion like this, where we're trying to get through more and more basic questions.
Yeah, of course.
Yeah.
And I mean, sometimes it makes sense to do that. I mean, a lot of people maybe aren't sure if their kids are financially coherent enough to handle a big windfall. And maybe it's not an enormous estate. It could just be a regular sized estate, but they've never seen that much money before. But we also, this is why we like to be involved early and often introduced to the family, because there's some other ways, not just trusts, right?
Oh, yeah. That's a big worry for a lot of folks is, you know, my kids, they're just, I've got, my kids aren't good with their money, or this kid is, and this kid isn't. And they really worry that when their kid receives the inheritance, that they might just blow the money, or that person and their spouse are just going to blow the money. We've seen it happen. It's a shame. I mean, we've seen some big inheritances literally go to zero. I mean, I've seen a $5 million inheritance go to zero, 800,000 go to zero. I've seen a lot of people inherit money and zero it out. So there are a couple, just real quick, there are a couple things. You could set up a spendthrift trust where your heir is not getting the money directly. It's in a trust with a trustee, and the heir needs to go to the trustee to extract principal. You know, they're entitled to all the income, okay? But if they want principal, they have to go to the trustee, and the trustee's saying, nah, not gonna let you get the Lamborghini. Nope, no boat, you know, nope, no trip to Australia. So the trustee is there. People have an inclination. Well, maybe should I make the brother, sister trustee? That's could be a nightmare. So usually you want a corporate trustee. Again, if we have a circumstance like that, we'll say, okay, here are the corporate trustees that we think would fit for this, this circumstance. If you don't want to go to try to control from the grave like that, we've been relatively successful where the client is saying to us, you're going to manage this money for my kids, right?
Yeah.
And yeah, of course we're going to manage the money for your kids if they'll have us. And we've been pretty good because this spendthrift kid, the first thing I want to know is how much am I going to get? What am I going to get? What am I going to get? Ooh. So what we try to do is phrase things in such a way to say, we're going to manage this money that your mom left you, and it's going to be in this account. And the first thing we talk about is income and not access to principal. And say, look, here's how much income you're going to get from this every month. And a lot of times, actually, that's very satisfying. Oh my gosh, I got nothing, and now I'm going to get $2,500 a month. And a lot of times, believe me, they're just right. They're just satisfied. Oh, Fort Pitt's going to send me this check every month, and they tend to leave the principal alone. So it takes some persuasion and it takes some trust, but we've done a good job of keeping some people from running through their money, from running through their inheritance.
It's a great way to legacy plan and have it be there for their children or their families thereafter.
Yeah.
Now, kind of a multifaceted question here. This actually came from a lot of our advisors. So a lot of our clients that hopefully are listening in ask this a lot of the advisors, and it's about, well, why don't I just add my kids on to my accounts now? Why don't I just add them on to my house now? And you kind of touched on that when you were talking about selling the house for $1, because if they're on as joint owners, then they have an equal right to that money. So the creditors could come after it. Right. It actually constitutes a gift, which may not be a big deal if it's not if it's still under that exemption, but still, that's something that you have to keep in mind. But maybe even bigger than that is they're missing out on the step up in basis, right?
Yeah, they still are missing out on the step up in basis. So again, you folks can tell we sort of frown on making your kids joint owners of brokerage accounts and your house and that sort of thing, because when you do that, you're giving them the money, you're giving them part of the house, and then they're inheriting your basis, and then they're going to have a capital gain on their share, which could end up being more tax than, the tax than the inheritance tax. The one thing I'm sort of okay with is, if mom or dad need help with bill paying and that sort of thing, I'm sort of okay with one of the kids maybe being joint on a bank account, a small bank account where it's a bill pay account, where there's not a ton of money in there.
Right.
I mean, if you're joint owner on a bank account that's $400,000 or $200,000, then when mom dies, you will have inherited half of that. And if you have brothers and sisters, then you do have to distribute. We don't have to. That's now your money. Your brothers and sisters may say, hey, that was $200,000. Can I get my piece of that? And generally, I think people are able to work that out. And whoever is on the bank account is going to write the checks and make sure people get their money. But you got to be careful too, because that's technically a gift. So it's again, this is something that really needs to be thought through, talked through with your advisor to say, should I be joint owner on this account with mom? I need to help her pay the bills. What about the house? Well, you guys have heard us about the house, other investment accounts. I mean, I did have a client who was joint owner. Mom made the son joint owner of the bank account. Mom lived to be 100.
Wow.
Son died before mom. My 100-year-old client inherited half of her money back. because she put her son on the account. So you got to talk about these things, and you've got to make sure these are sound, reasonable decisions, and we're not jumping through all kinds of hoops to avoid what ultimately is just a little bit of tax.
Absolutely.
You know?
Now, we've got about 10 minutes left, so there's a couple things that we want to make sure that we hammer home. And you've talked about it. And we think that, you know, gifting now could be a great way. I mean, I'm a great example. That's kind of how I got introduced into the business. My grandfather, who was World War II vet, just a regular old working guy, wanted me to learn about the market and gifted stock in a custodial account. And we work with people that like to do that all the time. And we work with their kids and make sure we can teach them about saving. So it's a great way for you to see how they get to grow up with the money and use it. And because it's great to pass on money, but sometimes it's even better to see them use it during your life.
It is.
So, and even if you don't have children, a charity, you know, you can be gifting money that way to reduce your taxes. So those are all really good ways that, you know, you miss out on step up in basis maybe if you're transferring it, but you're getting to accomplish what your goals are. So whatever those goals are, that's what we're here to discuss and prioritize and make sure that we're hitting each and every one of those.
Yeah.
Now, one other thing that I wanted to touch on was about, there's a lot of people that just invest on their own, and they do a lot of things on their own, more cost effective. So, you know, speak to those folks that may be, hey, I'm good. I've got everything on a spreadsheet at home. It's all up in my head. I'm good.
Yeah. There's a lot of do-it-yourselfers out there. God bless them. I'm a financial advisor. I'm not a do-it-yourselfer. I have help with taxes. I've helped with my estate planning. Believe it or not, even though I'm a financial advisor, I don't manage my own money. I don't pick stocks myself or my own. We have a team here. They manage my money for me. Why would I spend all that time? But some people are diehard do-it-yourselfers when it comes to managing their portfolio, and they're also do-it-yourselfers when it comes to their estate planning. And that's scary. I mean, this has to be done right, okay? I know some diehard do-it-yourselfers say, I'm gonna save money, darling, by writing my own will. And I'm gonna save money by managing this portfolio myself. You can tell I'm picking on the guys here, sorry, I'm picking on guys. But if your spouse doesn't know the plan and it's up in your head, or doesn't know your passcodes to your brokerage accounts, or doesn't know what the estate plan or your handwritten will says, that could be horrible. And we've seen it happen where the guy dies and the wife has no clue about where's the money, how's it managed, how do I get to it, what are the passcodes. I don't know where the will's in a drawer that's on a napkin. I mean, that's not good. And I think some people are trying to save money in the long run when then it costs a ton of money in legal fees and accounting fees to unwind and figure all this stuff out. So, you know, maybe this is the shameless commercial for what we do, but my gosh, when I think about how many, I've been doing this for 33 years, you've been doing this for 10 years, when you think about all the estates that we've settled, where the surviving spouse, one spouse dies, their surviving spouse, instead of saying, oh my God, I don't know what to do, spouse just comes in, meets with us. We take care of everything. Don't worry, we'll talk to the accountant. Don't worry, we're gonna talk to the attorney. Let's sit down with the attorney together. We're gonna move all the money around for you. Okay, let's look at the will. What's the will say? Who gets what? We'll get it to them. We'll do all the paperwork. We'll do all the transfers. You just need to sign stuff. Don't worry, we've got it all taken care of. So in a sense, for a lot of clients, we are their insurance policy that when someone dies, everything gets taken care of properly. Dealing with an attorney, dealing with an accountant. We do it, I mean, we have clients that die.
And you go
every
to
year.
those viewings.
And we go to the viewing.
Uh-huh.
If there's a viewing, or we send a check to the favorite charity. If you're a do-it-yourself or no one's showing up, or I'll pick on Vanguard. No one from Vanguard's going to drive to Pittsburgh or Central PA or wherever you live and say, "Here I am." That's what we do.
Yeah, I mean, I think above anything, it's just saving anxiety. Right, we're able to save fees most of the time, save anxiety, save taxes, just by having a conversation, and that's all. That's where it starts.
Yeah, and explaining it to the heirs. All right, it's a lot of times it's good to have a family meeting. All right, and explain to the heirs while you're alive. Okay, while you're alive, why don't we have a meeting where you want to bring your kids in, you want to bring your heirs, your nieces and nephews, or if you're leaving your money to charity, why don't we have a meeting with those charities and let them know whether or not they're going to be getting the money outright, or are they going to be getting it through a foundation account, which we help the clients establish. So all of this we're just talking about basic good planning, logical good planning to make sure everybody knows how things are going to move and how things are going to be distributed when you die.
Absolutely. I mean, there's so many questions that we didn't get to. We didn't get to the possible tax changes that are coming up. I mean, and we don't know exactly what that's going to be. Are they going to change the step up in basis? Is the federal state exemption going to be reduced? We're having these conversations all the time, but that's why it's important to have a financial planner to make sure that no matter what happens, that we have those conversations. Yeah. So I know we're coming up on time. Mike, was there anything that you wanted to add before we talk about what's coming up next?
Yeah, we have other good webinars coming up again, and I'll tell you what, I already know one thing. We're doing this one again. This one again, this one really had a lot of attention, so we will be doing this webinar again. The questions that we did not get to, we actually are going to, either your advisor team from Fort Pitt Capital, if you're an existing client, they're going to follow up with you to answer your questions. If you're not a client, we'll have advisors following up with you to answer the questions that you have. And please, hopefully this was motivation for you to get your planning done. Get your planning done. It's not like getting your teeth pulled. It's pretty easy when you come right down to it. Please get your planning done. We appreciate you attending. And Skylar, you want to just talk about these upcoming webinars? Oh,
for sure. So we were really thrilled that we had the most attendees, most registered. So
yeah, man,
that's why we're doing it again. But let's break some more records. So we've got some other ones coming up. So anybody that is an accountant, CPA, that's a great topic about IRA planning and mistakes. We touched on it a little bit, but how do we contribute to IRAs and make sure that that's proper? The key to your best exit, so talking about maximizing your value with business owners, college savings plans. So saving for kids, what's the best way to do it? We'll talk about the different types of accounts there and some strategies. And then here's our contact information. So our beautiful portraits are there.
I need a new picture.
Yeah. Well, and you were saying you need a haircut too, right?
Yeah,
it's almost getting the mullet.
Oh my gosh, it's getting cut tomorrow.
Okay.
Yeah.
Well, it's been fun to sit here and talk with you and talk through it, and we're looking forward to do it again. So share this with people you know and people you don't know, because it's a very timely topic, and we're excited to talk through it with you.
Yeah, thanks again. Thanks for attending. We really appreciate it, and have a wonderful afternoon.
All right, take care.